Thank you.
Good afternoon to everyone present here. I, Avneet Kaur, delegate of Sambhav Initiative and moderator of this event. On behalf of Sambhav Initiative, I extend a very warm welcome to our esteemed dignitary, Satyam Srivastav sir, and to all the participants in the last day of 1 week online national mentorship program, Supreme Court Law Clerk-cum-Research Associate Examination, organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah sir, former Judge of Supreme Court of India, where today's session will be on core legal subjects and analytical approach, wherein constitutional law, contract act, civil law, and criminal law, key concepts and principles, important and recent Supreme Court rulings in civil and criminal matters, developing an analytical approach to problem based and descriptive questions will be carried out. It is my privilege to introduce our esteemed dignitary, Satyam Srivastav sir. Sir is currently assisting the Additional Advocate General of Uttar Pradesh and has demonstrated exceptional academic and professional excellence in the field of law. An alumnus of the University of Delhi, Sir secured an outstanding All India rank 36 in the prestigious Supreme Court Law Clerk-cum-Research Associate Examination. Sir served as a law clerk cum research associate to Honorable Judge of the Supreme Court of India, Honorable Justice Padiwala sir, for 2 years, where he gained invaluable experiences in constitutional law, judicial research, and court proceedings at the highest level of the judiciary. His academic brilliance, combined with hands on experience at the Supreme Court and active engagement in high level constitutional litigation, makes him an inspiring figure to aspiring legal professionals. We are deeply honored to have you with us today, sir. Over to you, sir.
Thank you, Avani. Uh, I'm not sure who all are there. I'll just maybe see the gallery to have a better idea. Just give me- Yeah, so there are quite a lot of people in the session. Basically, this is the last day, so I'm not really sure what all has been told to you already, and if you have attended all the previous sessions. And honestly, I think the exam is only 2 weeks from now. It's scheduled for the 7th March. So there's not a lot of substantial changes that can be introduced at this point in time. I think all of you would be preparing well for the exams, and whatever preparation you would have put in is going to definitely reap fruits for you. And I think considering this is the last day and you have had the benefit of attending the previous sessions and receiving knowledge from all the esteemed dignitaries who have spoken here before, I would prefer that we keep this more of an interactive session where we can maybe you can ask whatever questions that you have overall about how to approach paper one, because this is primarily on paper one. And even if you want to ask questions about paper two or in general about what clerkship looks like, or in general any questions relating to this examination or what the nature of work is going to be, what the profile looks like, and how you can do better in the exam, how you can manage time. If there are any questions of that sort, I would prefer that we have a few questions in the beginning, and then I can structure the session accordingly, and I can try to answer those questions, and then we can proceed. And of course, I will share some of my insights on the general topic. But if Avneet, you may moderate the session a little bit and allow people to put some questions, and then I can note them down and I'll try to answer them as we go through the session.
Yes, sir. Participants, you can unmute yourself or can raise your hand if you have any questions or can write your question in the chat box.
Right.
Sir, what should be the approach regarding the recent landmark cases? Because this year they have not uploaded the cases.
Right, right. So, in fact, when we also appeared, so I was part of the first batch which gave this examination after this new format was reintroduced in 2023. I graduated in 23, and this was the first exam that I did. This happened 2 days after my last examination in college. So, honestly, I did not even have a substantial period of time to prepare for it. And I think in my batch as well, there was not a list of cases as such which was uploaded. So what I did and what my colleague also, who was a speaker here 3 days back, Mr. Arif Ali, what we did was that we went to LiveLaw and they have a quarterly, biannual, and annual digest of different categories of cases. And what we did was to go through it. We used to discuss a lot. So discussion helps because when you are there in an examination scenario, then something that you have discussed with someone else is going to act as a clue, and it will be something that triggers your memory and helps you answer that question better. So I think considering the short period that we are now working in, only 10 days or 12 days left, excluding Holi. So what is suggested is that you go through LiveLaw, or if there is any other platform that you use for reading case briefs, because at this point it is not possible to go through the judgments in detail, cover to cover. And at any point also it is not suggested that for preparing for this exam you have to go through the entire judgment. So maybe go through LiveLaw, see the top 100 or top 200 highlights of the year, which they are giving. And I would suggest that you cover the landmark decisions of the last 1 year and maybe 2 or 3 months more, because the period when Justice Chandrachud was the CGI, that saw a number of constitution bench judgments being delivered. So that would be very instrumental. So for constitution bench judgments, I would suggest that your approach should be to understand the core issue which was there, the question which was referred to the constitution bench, the composition of the bench, whether it was a unanimous verdict or whether there was a dissenting opinion as well, because you will find a few where, for example, Justice Nagaratna has dissented in, I think, two or three of them. So just see what the dissenting opinion is, what is the core reasoning in the majority opinion and what is the core reasoning in the dissenting opinion. And I think you should be good to go if you are able to cover these aspects for the constitution bench judgments. Other than that, I think for traditional civil and criminal litigation, a live law brief that accompanies when the judgment is reported on the application, I think that should be good enough for you to have a have a go at answering the question that might come regarding that judgment. And I think the core areas that might be asked in the examination are traditional criminal law, traditional civil litigation, arbitration, and constitutional aspects. So I use the live law resources. If there is any other resource that you follow, you can use that. But I think at this point, it's better to just briefly go through the landmark judgments instead of spending a lot of time on, let's say, reading five judgments and not being able to cover the remaining 10. It's better to cover all 15 and have a brief idea about all 15 of them.
Sir,
So,
in
yes, you can ask your question.
Yeah, sorry.
what context are you referring to arbitration that might come in the exam?
I referred it in the context of landmark decisions because the last 1.5, 2 years have been there has been a lot of development in the arbitration sector,
Yes, yes.
especially if you consider aspects like Section 11 jurisdiction and the difference between seat, venue, international in the context of international commercial arbitration, that there has been a lot of recent development. So I think a lot of questions might come from cases which pertain to arbitration as well, considering it is a very developing and nascent field as of now, and a lot of judicial development is happening. So in that context, I was referring to arbitration.
So there are a few questions in the chat box. First
Yeah,
is,
sorry. I'll just.
how difficult would you say this examination is, and how did you prepare for paper one? Any tips for revision of important topic?
Right. So the difficulty level, I would suggest it's not an easy examination, but it's not a very difficult examination either. The question paper, the good thing about the question paper is that it is not a memory based examination, rather it is a application based examination. Or at least it was so in the last two, three editions. I'm not sure how the paper is going to be this time. But considering the nature of work that law clerks are required to do, the examination has been tailored to test those abilities of students or the candidates, which is ultimately going to be required when they are going to join as law clerks to honorable judges. So the good thing is that it is application based, and hence it might be difficult for someone who does not have conceptual clarity, but at the same time it becomes a little easier for someone who has been thorough with their subjects throughout college. As regards my preparation, as I told, I only had 2 days to prepare effectively for the examination. Secondly, ours was the first batch which appeared in this new format. So I did not even have a lot of idea to as to what the exam format is going to look like, what the questions are going to look like. So in that sense, I did not have a lot of preparation, but uh, the thing which helped me was that during my uh, during my course at college, I was I was thorough with the subjects, especially the five main subjects which are there: CRPC, CPC, IPC, contract law, and constitutional law. The approach that I would suggest to follow in part one is that, considering it's an analytical paper, even if you don't remember, if you have seen the question papers of previous years, you'll see that sometimes they reproduce the entire provision as it is, or they modify the provision and make some important changes. So, for example, they'll introduce a word which is not present in the original clause, or in the original provision of, let's say, Indian Contract Act. So, they will copy paste the provision and they will add something or take away something from that provision. Now, if you are going to not apply your mind and understand the question and apply it to the facts before you, then you might commit a mistake, because the changing the provision will change the very meaning of the question itself. So in that case, the first approach, the first and most important thing is to read the question very carefully. This is something that might sound as very basic, but reading the question makes a lot of difference, because a few of my friends who gave the examination with me, they committed 4 to 5 mistakes, silly mistakes, despite knowing the law, because they did not read each word of the question and they assumed the question to be something which it was not. So read the question carefully, take the factual scenario at hand and apply it on the factual scenario. So it essentially becomes like a mathematical equation, that you understand the concept, or what the provision applies to which situation, it applies to which situation it does not apply, if there is an exception to it, or if there's an explanation to it, and then you see the factual scenario before you and you apply to it. You do not need to remember a lot of things for this, but just to get you in the flow of answering these questions, I would suggest that you read the Bare Acts of the five core subjects, and you go through the Bare Act, read them maybe 2 or 3 times. Just read the provision, try to get a feeling of what the structure of the statute is, from where it begins and in what direction it is flowing, what are the areas that it is covering. Read the illustrations very carefully, which are given in the original statutes. The illustrations are going to be the basis of at least 5 to 10 questions, in my understanding. In my year, at least 6, 7 questions were directly from illustrations. So if you are well versed with the illustrations, aware of what examples are used in what sort of a provision, then I'm sure it will be very helpful for you. And this is regarding paper one. And I'll see what are the other questions. First question, I'm sorry, I'll just scroll up and see what are the questions chronologically. We'll come to the question number 3 of paper 2 later. How difficult with the examination is done. Cutoff date for studying judgments. Yeah, definitely. Judgments from 2026 are very important, because in the last year's question paper, judgment which was delivered a day before the date of the examination, I think, or 2 days before the examination was asked. So you have to cover everything till maybe one day before the examination is scheduled. So I would suggest that a safe date is 27th February, because uske baad there are holy vacations for a week. So try to cover all the judgments, landmark judgments which have been passed in the year 25, complete entirety of 2025, and January and February of 2026. Paper 2, question 2. So if can you just confirm, Avneet, because I'm not aware of the format right now. Paper 2, the question 1 is brief making, question 2 is research memo, and question 3 is the analytical descriptive, where they give you a question and you have to choose one of the topics and write. Is that so?
Yes, sir.
Okay. So paper 2, question 2, I think the previous session is was on paper 2, question 2 only, and in which Arif was the speaker. And it would
Yes,
be
sir. It
better
was
that
preparation of the draft research memo. It was.
right, right. So that is paper 2, question 2.
Yes, sir.
And I think you guys upload the recorded video of these sessions
Yes, sir,
somewhere.
that are uploaded on Google Drive as well as on YouTube as well, sir.
Correct. So you can share with this concerned person who has some queries. On research memo, again, I would give my quick insights. A research memo, you have to understand that what is the objective of writing a research memo. When you are working as a law clerk, the honorable judge might might hear a case in the court during the course of the day, and you'll see that 90%, 95% of the cases are decided and disposed of in the court itself. But then there are certain cases which involve questions which on which there might be some confusion or which have arisen before the Supreme Court, let's say for the first time, which are called substantial questions of law or questions of general importance. It is on those questions that your boss, if you become a law clerk, is going to maybe ask you to assist them as to how to approach that question. Now, the question when it comes to you, research memo has to answer a issue which is before you, and it has to cover the aspect that is being put forward by the petitioner as well as by the respondent. Now, let's suppose I'll take an example of a recent case that I was personally dealing with, not as a law clerk but as an advocate. So the question pertained to a question in the juvenile arising from the Juvenile Justice Act. And just to give you an illustration, so in Juvenile Justice Act, there is a concept of criminal revision which is filed if if a juvenile is taken in custody in relation to an offense, he applies for bail before the Juvenile Justice Board. If his bail application there is rejected, then he files a criminal appeal before the Children's Court. And if the criminal appeal also fails, then he has to file a criminal revision before the concerned High Court, Section 102 of the Juvenile Justice Act. Now, Juvenile Justice Act, Section 102, if you read, it says that no order shall be passed without giving a reasonable opportunity of being heard to any other party which is aggrieved by which could be aggrieved by such an order. Now, when we file a criminal revision here, then we have to make the complainant or the first informant in the FIR a party to that criminal revision, and a notice is issued to that complainant before my criminal revision is heard. Now, if you compare this with, let's say, the bail provision under criminal procedure, CRPC section 437, there is no requirement of making the complainant a party in a bail application before the High Court or before the Sessions Court. Now, because of this discrepancy, there arises a situation where, let's say, there is a commission of a murder, and two people are accused in that. One person is above the age of 18, and one accused is under the age of 18. The person who's above the age of 18 will make a bail application before the Sessions Court, and if he fails there, he'll come to the High Court, and he does not need to make the complainant a party to that bail application. And if the juvenile, the person who was under 18, the accused, if he fails before the Children's Court and the Juvenile Justice Board, then he'll need to file a criminal revision before the High Court. And here he'll have to make the complainant a party. So prima facie, if you look at this situation, this is giving rise to two different procedures for two different accused persons merely on the basis of their age. One is under 18 and one is above 18. So this question was raised before the Supreme Court, and notice was issued in this. And now, once the judge issues notice on this question, and this is a question which has not been answered by the Supreme Court yet, and this is pending consideration even today. So now, when the judge will hear this matter and come back in the evening to the office, he might ask you that, okay, this is the actual situation before you, as I just described, and you have to prepare a research memo on this. Now, as a researcher, your first job is to frame the issue, which is the key of the matter. The issue here is whether issuance of notice to a private complainant is mandatory before their bail application can be heard before the High Court. Now, this is the issue that you have to answer. For answering this issue, you need to go back to the how you will start answering this. The first thing that you need to see is what are the provisions which govern grant or refusal of bail to a juvenile as compared to grant or refusal of a bail to a normal adult accused who is above age of 18. So there are two provisions. You'll start by decoding. You'll first frame the issue. The issue, as I've described, is this. Now, the second step would be, what is the legal framework which governs this issue? The legal framework will then be divided into two parts. The first part will be the Juvenile Justice Act, Section 102, the Section 102 of Criminal Revision, and other relevant provisions of Juvenile Justice Act. For example, the provision which governs bail before a JJ board, Juvenile Justice Board, Section 12, criminal appeal, which would be Section 101, and criminal revision, which would be Section 102. So in your research memo, you have to summarize what these three provisions are, and you also have to scan the statute and see if there is any other provision which is pertaining to grant or refusal of bail to a juvenile. On the second aspect, now you will see what is the provision for grant or refusal of bail under CRPC. So you will go to section 437 and you will see what are the principles and procedure which govern bail. So this will be the statutory framework. First you frame the issue, then you analyze the statutory framework. After you have analyzed the statutory framework, the third thing that you have to see is what is the current and existing legal position on this issue. For this, you'll need to refer to judgments. What could be the judgments? In this case, because there is no Supreme Court judgment which directly covers the issue, you will have to see if there is any decision of any of the high courts which governs this. In this case, you'll find that there's one decision of the Allahabad High Court, one of the Rajasthan High Court, and one by the Delhi High Court. There are three decisions which govern and answer this issue, however, differently. Delhi High Court and Rajasthan High Court answer it in one way, and they say that issue of notice is not mandatory. Whereas Allahabad High Court has a very elaborate decision which says that issuance of notice is mandatory under Section 102 of JJ Act. So this is the legal position. So now you have covered what already exists. You have framed the issue, you have seen the provision, analyzed it. You have also gone through the current and existing judicial position on the issue. Now what is left is that you have to give a concluding opinion, or you have to do a further what is the value addition that you can do. This would be the analysis part. So in analysis, you will say that in my opinion, or as a perusal of the legal provision and the judicial position existing on the issue would show, currently this is the position. However, for example, if I am drafting this, I would say that issuance of notice is not mandatory, because the object of Juvenile Justice Act is to expedite the process of bail for a juvenile, not to further delay it. So I would say that, considering the object of Juvenile Justice Act, which is evident from the sections, or the, let's say, the statement of objects and purposes, uh, a juvenile is to be enlarged on bail as expeditiously and as possible, and issuance of notice to the private party further delays this process. And also, having two separate procedures for a juvenile and adult is violative of Article 14, because without there being any reasonable differential, two different procedures are being followed. And hence, in my opinion, the issuance of notice should not be mandatory. Decision of Rajasthan High Court and Delhi High Court should be upheld. So this would be my opinion or analysis of the matter. This would be the analysis of the matter, and then you have to finally conclude that this is the issue, and the issue is addressed that issuance of notice is not mandatory. Now, this is how it works in real life. Now, in your examination, what you will get is that they'll give you, let's say, 15 provisions of the JJ Act, 10 provisions of CRPC. They'll give you 6, 7, 8 decisions, and then they'll ask you that this is the factual situation. Write a research memo, draft a research memo. When you are going through the materials, you will see that out of the 10 or 20 provisions that they have cited in the question paper, only 5 or 6 would be relevant. For example, in this case, 3 provisions from JJ Act and 1 provision from CRPC are relevant. So you have to choose that for this issue, only these provisions are relevant. Then you'll have to go through the judgments which they have given, and you will see that maybe 3 or 4 judgments are relevant, 5 or 6 are irrelevant. So you have to quickly skim through the judgments that they have cited in the question paper. You have to decide that these are the relevant questions, these are the relevant decisions, these are not the relevant decisions. And based on the relevant provisions and the relevant decisions, you have to structure your research memo in this format. First with the issue, then with the statutory framework, third with the existent judicial position, judicial framework, fourth would be the analysis, and fifth would be the conclusion. This is on paper 2. Sir, in brief making, is it preferable to write it in list of dates format? The entirety of the brief cannot be in list of dates format. you can have some of the key dates which are mentioned. Because if you are ultimately going to make it an entirely list of dates format, then the judge would rather read the list of dates which is present in the petition itself, because every petition starts with a synopsis list of dates and then goes to the main petition. So you do not need to keep it entirely in LOD format. You can have a list of dates on which previous orders were passed, the important orders, and in list of dates you can have the key dates. Am I still audible? I think my earphone might be a bit
Yes,
bad.
sir, you are completely
I am
perfect.
okay. 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 So in this case, you need to just give me one moment. I'll put my laptop. Right. So you need to figure the key dates. A lot of dates which the person who has drafted the petition, which he'll put in the list of dates, I would say that 70% of them are not key to deciding the matter which is there. And you also have to understand that a brief is also to be prepared from the perspective of the Supreme Court. And what is the Supreme Court required to do under the Constitution? The Supreme Court is not required to adjudicate on questions of facts. The Supreme Court is required to adjudicate on questions of law. Primarily, this is the object with which matters are heard in the Supreme Court, to settle any uh, disputes as regards position of law. And there are then other categories as well, but generally this is the position. So your focus should be on how you can, in 1 or 2 pages, how you can help the judge in figuring out the question which is arising from a given factual scenario. You have to always keep an eye on the ultimate object with which the brief or the matter is being prepared. It is not being prepared to make the judge aware of every factual thing which happened during the course of the matter before the High Court and before the trial court. The object is to only narrate minimum quantity of facts which will help the judge figure out the question of law, and the question of law arises in which factual matrix and the factual situation before them. So keep this in mind. Do not make it an entirely list of dates. That's my opinion on it. If you think you're more comfortable with that, and if you can still do a better job in a LOD format, then sure, you can proceed with it.
So
But I
the
think, right,
so the LOD format we have been asking for is, as we saw format in our previous lectures, in which
right,
the dates were given, like the
hmm,
impugned order was mentioned
right,
with the date on left column, right? And the whole
right,
judgment and its findings were written in another column on the right side. So that
right,
whole brief was written in this format. Like if we have a arbitration in question, the impugned judgment, the trial court order, all of that was written in the LOD format. And in
right.
each column, the findings were also written. So will that be preferable format? According to you, the
Okay,
facts weren't mentioned in it, actually.
so none of the facts are mentioned.
The important, like the impugned judgment was
Hmm,
passed on this date, and the findings were
hmm.
so and so. This was the major format of LOD.
Right. So impugned judgment forms the most important part of a case brief. So, however, the format that I used to follow, even when I was briefing uh, the judge I was working with, as well as when I appeared in the examination, was that we would um, first write a 3-page synopsis, a three-liner synopsis. So the first line would have the key details of the case. Then there would be a 2 to 3 liner as regards what is the core thing. For example, SLP criminal or civil number this, arising out of judgment dated this, passed by the Delhi High Court or Allahabad High Court in this matter, wherein this order was upheld or set aside, and let's say arbitrator was appointed, or uh, suit the suit for cancellation of sale deed was decreed, or whatever be the gist of the matter, the crux of the matter in those 3 lines, so that on first blush, in the first reading, the person who's reading it should know that this is what happened at the first level, this is what happened at the second level, and this is why it is being challenged before me. This is the first thing. Then what the second thing that I used to write was uh, the previous orders, the record of proceedings. So I think that is not available in the question paper. So this is something that can be skipped. because i- generally what we have to do is, for example, if this is a matter which is coming at an after notice stage, so it means that 6, 7, 5, 4, whatever number of hearings have already taken place, and there would be some order by a coordinate bench or this bench itself, wherein something would have been recorded. But however, in the exam, I think this is not there, so you can skip this. Then there was a finding on limitation if there is a delay. So if there is a delay in filing of the matter, then you have to mention it right after you write the particulars of the matter, that there is a delay of this many days. Then we would start with the brief facts. And brief facts would include the very essential bare minimum facts which are necessary for getting to understand the crux of the matter. So you would mention the brief facts, and then I would come to the impugned judgment part. The impugned judgment. So I think what you are suggesting, Monica, is that the brief that you saw had the facts taken from the impugned judgment rather than a brief facts column or heading being separately dealt with. But I would suggest is that you do not rely solely on the impugned judgment for facts. You also go through the trial court decision if there is any. You also go through the high court decision if there's any. You also read the petition cursorily, which is there before you. And on a cumulative understanding and reading of all of these things which are before you, then you should go about drafting the brief facts. If you solely rely on the impugned judgment for facts, then there might be an incorrect finding of facts in the impugned judgment, and you do not want that incorrect finding to further translate even before the Supreme Court. So it's better to read all the material that is before you, and then, as per your understanding, preferably in a chronological order, and if that is not possible, then in a manner which is easy to read and understand. You should write 6, 7 points on brief facts. Then you should come to impugned judgment. Then on grounds, you can have maybe 4 or 5 major grounds. If there is a substantial question of law, then there should be a separate heading for question of law or questions of law. Then the prayer which is there. In some cases, there will be a important interim prayer as well. So if there is any interim prayer, then you should have a separate heading for interim prayer and prayer and interim prayer, and that should be good. This is the format that I used to follow. I'm not aware if there are any changes in the prescribed format by the Supreme Court this time, but I think it's ideal to stick by the format which is prescribed in the handbook or the material which is uploaded on the official website, because the examiners will also get a same format to assess your question papers and answer scripts, and you would have a higher probability of scoring better if you stick to the format that they prescribe in the material that they've
So,
uploaded.
so regarding dates, what we can
Hmm.
do is rather than making it a list of dates format, we can
Yeah.
figure out the important dates and we can include it
Yes.
within the sentences only. Like a decree was passed on so and
Correct,
so
correct,
date.
correct. This is what I used
Correct.
to do as well, and I
Okay.
used to. So when I type it on my laptop, I used to bold the dates. What you can
Hmm.
do is you can underline or write the dates in black and rest of it in blue, or whatever combination
Okay.
suits you. You can do something like that.
Oh, thank you.
Sir,
Yes.
I have a
What are
question
the
relating to the research memo, that the
right,
judgments which are relevant, if like 5 judgments are relevant, so whether whole
right?
sentence of that judgment should be written or noted down.
No, no, no. See, the object of research memo, when you are answering the question paper, see, there's a difference. So this is where I think a little different approach is to be followed. When we do it in real life, so the question paper is not a real life scenario that you're dealing with. You are answering a question paper. When we prepare a research memo actually for a case for the judge, then of course we reproduce, copy, paste the relevant extracts and we keep it in the research memo if there is any extract. However, in an examination, you cannot afford to waste time on copying something which is already there. So it's better to summarize it in your own terms, in your own language, the crux, the essence of what the finding was in that judgment. And in brackets, you can refer to para numbers 4 and 5 of the decision in this case. I would strongly suggest that do not waste time in reproducing what is already written in the material which is provided to you in the answer script. This is only a waste of time. Reproduce if at all you want to reproduce it, rewrite it in your own language as crisply as possible. And after writing your sentences, you can in a short bracket you can say refer to para numbers 5 and 6 of the decision in this case.
Hello.
Yes.
Hello, sir. This is Devajit. Sir,
Hi, Devjit.
as you told us, you prepared for the exam with only 2 days of preparation, appeared for this
Right,
exam. So,
right,
what was the your strategy for the quick revision 1 or 2 days before the exam? Because I am currently practicing as an advocate, so I
right,
don't
right,
I don't have much time to read this all section and all. So, this is
right.
the question.
So, I would also give a little background on what happened before I started preparing for the 2 days of examination. So, I was fortunate enough to get an internship opportunity with the then CGI, Justice Chandrachud, which lasted for around 1.5 months. So, most of my paper two was prepared during my internship with the Honorable Judge. So, when I say 2 days of preparation, don't take it on the face value. This 2 days does not include the preparation that happened even before the examination form was out. So, because I was well versed with brief making, I was habituated of making briefs during my internship period, one at the Delhi High Court and one at the Honorable Supreme Court. So brief making was sort of covered for me. The second question was the research memo. We only had two questions when we appeared for the examination. The third question was added the next year. On the research memo, I am from Campus Law Center, University of Delhi. So the examination there is in the same format in which paper two, question two of paper two, is asked. So it was also sort of not very difficult for me to understand how to answer question two because I was used to answering questions in my examination for the previous 6 semesters in the same format itself. And for the brief making, because I had interned, my brief making was covered. So for preparing for the exam per se, I only had to prepare for paper one. And for paper one, I can give you a quick strategy that I followed. One was that I went through the Bare Acts of as many subjects as I could in those 2 days, starting from the Contract Act because it's a relatively easier and smaller statute. And then I also went to CRPC and IPC and the illustrations therein. For IPC and CRPC, I would suggest that it's not humanly possible to go through every provision in detail. So it's crucial to go through the key provisions. For example, in CRPC, you can maybe see the provisions pertaining to arrest and then starting from FIR up to conclusion of trial, then provisions pertaining to criminal appeal, revision, and bail. I think these five are the most important sections of the CRPC. For IPC, I would suggest that you can see offenses affecting the human body primarily, and then maybe financial offenses, cheating, fraud, forgery, etc. I think if you go through these, this should be good enough because we are working in a time bound manner. Hence, you'll have to pick and choose if you can afford and if it's possible for you, then I would suggest that go through the entire Bare Act of all the subjects which are mentioned in the syllabus.
And for
And
C and
secondly,
CPC, sir, CPC, Code of
yeah,
Civil Procedure.
CPC, I would be honest, I did not go through it. I trusted what I had studied during my classes, and I was fortunate enough that CPC paper was not that difficult in that year. So I don't know if there is a shortcut for CPC. CPC being so broad and vast, it's difficult to find a shortcut. But again, I can maybe suggest that at least go through the sections, if not the orders and the rules. You can go through the sections for orders, maybe the orders which are pertaining to execution, some of it, and the plaint. But then all of it is at some point, all of it is very important. So if you have time, then maybe read CPC, or if you are not confident in CPC, then I would suggest that do not spend a lot of time trying to get acquainted with it at this point. Just use that time to cover something which you are good at, and that would be sort of a calculated risk that you can take. You can skip those questions and you can do better in the other questions, which on subjects in which you might be more comfortable.
Okay, sir. Thank you, sir.
And for the judgments part, as I said, I only went through the live law brief. I and one of my friend just used to ask questions from each other. I think we would have seen some 200, 250 decisions, and randomly we would keep asking questions on those judgments. And fortunately, most of the judgments which were asked in that year were from from the judgments that we had referred to. So this is a quick strategy because since you have more time than just 2 days, I would suggest that you also focus on brief making a little bit more and trust maybe your instincts and your previous preparation for paper one.
Thank you, sir.
Satyam, hi Satyam. So
Yes, yes,
I have a couple of questions to ask. Like firstly my question is, do you think
yeah,
for paper going to the past year papers,
yeah,
especially since the pattern has changed since 2023, so going through
right.
even past papers as well as the paper that asked in the Delhi Judicial Prelims exam, is
Yeah.
that enough to the paper
Yeah,
one?
yeah, I
Because
think that is more than enough, but I would suggest you go through the papers for law clerk examination first. I think there would be three of them now, 23, 24, 25. You go through those three papers, then there would be a sample question paper as well, I think. So
oh,
I think you might have access to 4 or 5 question papers as of now. Go through
so
those question papers.
is it
Hello.
feasible or is it feasible
Mhm.
to go through papers since 2015 of the law clerk examination?
No, 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 no. The format has entirely changed after 2023. So till
Okay,
2021, it was a very different format. So I don't think
okay.
it would add a lot of value if you go through the 15 to 21 papers now. Go through the papers from 23, 24, 25, and the sample papers. You will get an idea of the nature of questions which are being asked, and then spend the balance time, I think, on going through the Bare Acts and understanding the concept and illustrations which are there in the Bare Acts. Rather than
But
practicing a lot of questions, it is better and more advisable to be more comfortable with the Bare Act, the structure of a statute, etc.
but Satyam, like my question is, as you also are aware that it is not possible to cover the entire Bare Act, even if you have months to prepare, like it is not possible to remember each and every section of the Bare
I
Act.
as if you remember in the beginning, I said it's not about remembering. The question paper does not test your memory at all. The question paper tests your understanding of how, if you can comprehend the provision and if you can apply it to a factual situation more than it tests your memory. There might be a few questions which test your memory, but most of them are not going to test your memory and rather check your application and aptitude as well as comprehension. So reading the Bare Acts, I'm not saying read it from a perspective that you have to remember and memorize every provision which is there. It is only to understand how the provisions work, how the illustrations are there, what is the language which is used in a Bare Act. Because unless you read the Bare Act, you will not get comfortable with the language in which the statute is framed and drafted. So I'm only saying this to get yourself more familiar and acquainted with the provisions so that when you have to answer it in a time bound manner in the examination hall.
Oh,
Sir,
okay.
you are not audible. Can you please
Yeah,
repeat
yeah, I'm
that?
sorry. I think my Bluetooth just. If you'll give me a minute, I'll get my other earphone and get back to you in a minute.
Yes, sure, sir.
Yes.
Hello.
Yes, sir.
Yeah, I'm
Hi,
audible
Satyam.
now.
Yes, sir. Now you're audible.
Yes, yes, yes. Yes. Any other question?
Yeah, hi Satyam. So, like my question, my second question would be like, since you said that you have prepared for the 2025 judgments, you have gone through the 25 but you are saying that we have to go through the 25 judgments as well as till 27th February of 2026. Is it also necessary to go through landmark judgments of each area of law, such as arbitration, criminal law, separately?
No. So when you would go through the, let's say, live law digest, which is the annual summary of the entire landmark decisions, there would be 100 cases, I think, in that. So I
Okay.
think you should necessarily go through the 100 judgments which are there in the annual digest. Then you can also go through uh, there are topic wise and subject wise area of law wise digest as well. So, for example, there would be a top 100 judgments of criminal law, top 100 judgments civil law, 50 or 25 major decisions of arbitration. So, go through live law. There is a separate column on their website or on the application itself wherein all the digests are compiled. See the maximum number of digests that you are able to cover, the better it would be. But preferably go through the landmark decisions of the last year on a priority basis, and then maybe you can, if time permits, then you can go through the subject wise and area of law wise major decisions.
Okay, and let's say while answering the research memo, or let's say the
Yeah,
application based in the question paper two. So
yeah,
sometimes the trial court has a different findings, and then the high court has a different findings altogether. So
yeah,
since the word limit is very concise in nature, so
right.
how to like summarize those judgment while making the memo, or let's say the note?
The brief, I would assume this is pertaining to the brief, right?
Yeah.
Not the research memo, because I think there's no trial court judgment in the research memo.
No, I'm so sorry. I'm
Yeah, yeah.
asking.
Yes, yes. So in the brief, see, if they are going to give you a very comprehensive, detailed brief, uh, then maybe you can see if there are different findings, then ideally it is suggested that you summarize those different findings, because then you will see that the petition will rely either more on the High Court's finding or more on the trial court's finding, depending on which side has filed the petition. So, if there are differing findings, then it means that one court ruled in favor of the petitioner and one ruled in favor of the respondent. And then we'll have to see whether the petitioner won at the stage of the trial court or at the stage of the high court. And if the petitioner had a successful outing at the trial court, then you will have to include the findings of the trial court in some detail, because we would want the judge who would read the brief would want to know that why did the High Court overturn the findings? What was the reason for the High Court? Whether High Court considered and went into the details of the findings given by the trial court. So maybe you can uh, go a little above the word limit, or ideally, I would not suggest that you exceed the word limit. But if you have to choose between including the detail and exceeding the word limit, I would say include the detail. But if you can manage both, then that would be the best case scenario.
Okay, thank you so much.
No worries, no.
So
The
Yes.
like
word limit,
Sorry.
so the word limit we have been given is like 750 words for the brief writing.
Right.
But the suggestions we have been getting to write the brief
Yeah.
is to about one to 1.5 pages, right? But the
Right.
brief given to us in the sample Supreme Court
Hmm.
document also, that runs to around 1.5 pages. That if we write it
Right.
down on with our handwriting, it would almost
Right.
cover 2 and 2.5 pages. So would that be
Right.
feasible to write, or
Number
we
of
are
number of pages should not be an issue. You cannot change your handwriting at this stage, so that is something that is beyond your control. But try to, if there is a 750 word limit, maybe you can go 50 or 100 words up or down. Down would not be suggested, of course, but 50 or 100 words above it should not be an issue.
if you're able to condense it into, let's say, 2 pages. The idea of a brief should be that in reality, it should be a single piece of paper which you see and you know what the matter is. So try to be a little more concise if at all possible. Sometimes we want to write a lot of things, but honestly, a lot of it is not important. So you do not have to frame proper sentences. You can just write it like a bullet points as well. That the trial court decided, the trial court held, and then this, rather than saying that the trial court by their order dated this ruled in the favor of the petitioner and decided. So we are not writing a judgment, we are only making a brief. So it's not essential to frame proper sentences. You can write it in bullet points to cut down on words. But the idea is to have every thought and idea which is going in your mind and every important factor which you found while going through the file, it should be included. So language, sentence, presentation is important because it should be readable, but I don't think language is a very key factor. Keep the language a little to the point, and that will help you to include more ideas in lesser words.
Sir,
Hi, sir. Hi, sir.
yes.
Good afternoon. I'm audible.
Hi. Yes, yes, you are.
Sir, I wanted to ask about paper one strategy with
Yeah.
0.25 negative marking. How many questions did you attempt? And would you recommend us attempting all 100 or sticking to a safer range?
Right. So I attempted, I think, 97 questions. I wanted to attempt 99, but because time was up, so my answer script was taken away. Uh, it was a lucky day for me because I think I only committed mistakes on six. So I had 91 right and six wrong. But I attempted 97 only because I was confident that every question that I am attempting, either I knew 100% or I was at least sure that it is one of the two options. So you have to take a calculated guess. I would not suggest advice at all that you attempt all 100 because I think this time the cutoff is 60% as compared to 50% for the last year. So if you are on a thin margin, let's say you know that 75 questions, you're confident about 75 questions and not confident about 25. And let's say you attempt 75, which you're confident about, you get 70 right. So that's plus 70 and you get 30 wrong. So 30 wrong would mean that 7.5 is a negative score. So with that, you would be 62.5 in total. And that is a very thin margin in my understanding. You should not play with such a thin margin. If you are confident about 75 as 100% sure options, and let's say five questions where you are confident that it is one of these two, then I would suggest that you only attempt 80 questions. In that case, if you get, let's say, 70 out of 75 right and one or two out of the five that you guessed right, then you will have plus 72 and minus 2. So you will get a score of 70, which is above 10 more than the required cutoff. So it's always better to be on the safer side rather than play on thin margins. I know a couple of my friends who missed out on the paper one cutoff by zero point 0.5 or 0.25 even. So you do not want to have a very good paper two and then not be able to clear the exam because you could not meet the minimum cutoff. And keep this in mind that paper one is of a qualifying nature as well. So unless you get 60 or above, your paper two will not even be evaluated. So irrespective of how good you were at paper two, it will only be calculated and evaluated if you score above 60 in the first paper. So the objective is to score above 60 anyhow, and thereafter, if you think that you can attempt more while being in the safer range of plus, I would suggest that you target 65 above if you want to be on the safe side. And if you once you are in the 65 plus zone, then you can take maybe 5 to 10 additional guesses. Otherwise, if you are confident that above 60 is happening and you're not sure about the other questions, then I would suggest that you skip it.
Fine, sir. Thank you. And could you
Yeah.
please help us with the constitution and contract important topics also?
Uh, Constitution, like I think everyone would say that go through the part three of it, the fundamental rights. then go through the state and the union legislature portion. Supreme Court articles pertaining to Supreme Court would be very important, and I think this should be good to go. Maybe also go through the emergency provisions and the Amendment 368. I think these should be the relatively more important topics. Also, see what are the topics uh, which have been considered in some of the judgments recently. For example, the articles pertaining to disqualification of members of the assembly and parliament. That is something that is going on in the news and has been part of some judgments. Then you can also see the power of governor to withhold bills. Article 200 of the Constitution. That was part of the presidential reference. So all of these would be important, and otherwise also the topics that I mentioned. For contract, I'm not really sure. Maybe the first 60 sections 1 to 60 are the 1 to 80. In fact, I would say 1 to 80 to 85. I think they are the key provisions. So you should be familiar with them at least.
Thanks a lot, sir. This really clarified things for me.
Yes,
Thank you.
yes. I
Uh,
think we are reaching 2 p.m. I have got to go to some other
yes, sir.
thing as well. Yes.
Yes, sir. So thank
Can
you so
we?
much, sir. And on
Yeah.
behalf of Sambhav Initiative, I extend my sincere gratitude to you, sir, for delivering such an insightful session and answering all the queries of the participants. Thank you so much, sir, for accepting our invitation and taking time to guide and inspire all the participants. And I would also like to express my deepest gratitude towards our patron in chief of Sambhav Initiative, Honorable
Right.
Justice C.K. Thakkar, sir, and patron of Sambhav Initiative, Honorable Justice M.R. Shah, sir, under whose vision we were able to conduct this 1 week national capacity building program for the law clerk examination. Thank you so much, sir, and thank you all the participants for joining. Looking forward to host you. Thank you so much,
Yes.
sir.
Thank you. Thank you so much, Avneet. I also really enjoyed getting in touch with everyone. Takes me back to 2023. Our exam happened in June, so we got maybe 3 months more than you guys are getting. But yes, I'm sure with decent preparation, you'll enjoy the question paper a lot. I mean, the process of answering the question paper is very enjoyable, regardless of the results. It is a very uniquely drafted question paper. So I really enjoyed the process of giving the examination. The questions were quite intriguing, especially part one of the examination, because you feel like there is some place where your actual application of mind is being rewarded and not just rote learning. So I would suggest that you go and enjoy the question paper. Um Try to manage the time a little bit smartly so that you can attempt all three questions in paper two. Try to attempt every question that you are confident about in paper one, and I think you should be good to go. There is one question about internship under SC Judge. So I applied for an internship with Justice Chandrachud through a Google form that they had back then. So it was a process where I applied and they had a briefing test after it, and they selected 6 or 7 candidates every month. I think there are some other offices right now as well, which accept internships through Google Forms or emails. So you can try to uh, maybe reach out to law clerks who are currently working with those judges or offices. They can help you in figuring out if there is a open, transparent procedure for applications. Otherwise, I can understand that it can be difficult for someone who does not have maybe contacts to offices in securing an internship. But yes, there are offices which are taking it through a fair and transparent procedure. So I would suggest that you reach out to offices and ask if they have a procedure wherein you can make an application and get selected. I think, yeah, I'll take your leave. Thank you so much for
Thank you
being
so much,
patient.
sir.
Yes, yes. Bye.
Thank you.